Hi, everybody. This is Steve Maggi from SMA Law Firm. Welcome to another episode of Building the Bridge. And I have the honor of and privilege of being with Tiffany Comprés today, who's an international arbitration and litigation attorney based in Miami and in Paris. Thanks so much for joining us, Tiffany.
Thank you for having me and for having Frankie, my little lazy assistant.
So a question, we already mentioned what you're specialized in. Now we want a breakdown. What is the difference between litigation and arbitration?
Okay, so let me start by explaining what arbitration is briefly. Arbitration is like a private court. You hire the judge, you're outside of the public tax-funded court system, right? And the benefits are huge for international business. The biggest difference is that you can have your arbitration award, the judgment that comes out of an arbitration is called an award. You can have that enforced internationally much more easily than you can a judgment from a court in any country. So let's say I've got a dispute with somebody in Panama. It's much easier for me to get an arbitration award and enforce that in Panama. Or if they have assets, let's say in Paris or Belgium, it's easier to take that arbitration award and get it enforced in those countries than it would be to take a US judgment and get it enforced in any country, or vice versa.
And litigation is the opposite, I guess, of that, right? It's
right, precisely
specific to one jurisdiction, correct?
Exactly. It's much more difficult to get those enforced internationally. And then, obviously there are other differences that flow from the very different nature of the two, right? One is private arbitration. It's private, it's confidential. You choose your judge. You control the process more than the judge controls the process. You have a lot of flexibility in how you schedule and how you arrange the case. The parties, for example, might decide that there's an issue that needs to be determined earlier because that will change the entire path of the proceedings, right? Let's say you have a question of law that will completely change how the proceedings go on. You can have that addressed very early on easily, right? When you're in court, the judge is calling the shots, especially in civil law countries and in United States federal court, you really have the judge calling the shots and you've got very little flexibility. So that can be a huge detriment. Most of the time it is. It's not confidential. All of the stuff is in the public record. When you're in a court, you don't choose your judge. Your judge is completely a lottery. Right. Your judge may or may not be familiar with your industry. Your judge may or may not be familiar with the laws that are at play in that particular situation. So there are significant benefits to arbitration, but really the biggest one and the biggest difference is the ease of enforcing your ultimate judgment or award.
And this may not be a PC follow-up question, but in my home country of Argentina, the judges are known for being very protectionist, meaning they tend to side they tend to take the side of the Argentine company, even if it's really there's usually some sort of middle ground where the decision should really be made, right? Not everybody's completely in the wrong or in the right, but they're very protectionist. That's probably true in other countries as well, which means you're getting an adverse decision in one country, and then you're probably going to have to figure out how to, dispute it or maybe do a parallel case somewhere else. And then you've got multinational messes going on, which just incur more and more costs, right?
Exactly. You're exactly right. There's that big domestic pull in the courts. And it's one of the reasons that international arbitration is the dispute resolution method of choice for international businesses, because you can choose your own arbitrator who doesn't have that domestic bias, right, towards either party. They're really neutral. They know about your business. You can choose somebody that's got experience in the kinds of laws that are at issue. And that can make all the difference.
How does one avoid, maybe taking a step backwards, because I was going to say this all has to do, framing this for our viewers, this really has to do with dispute resolution on a business level and an international focus to it. But how do you avoid that? And are there ever cases where there's a settlement before it goes to arbitration?
Yes. That happens all the time.
Sure.
There are a couple of things that you can do in your arbitration clause to make a pre-arbitration settlement more likely. One of them is, or the primary one rather, is to include what we call a tiered clause. So you require the parties to mediate before they're allowed to go into arbitration or to court for that matter. These clauses have to be extremely well written because as an arbitrator, I will tell you, one of the biggest issues I see recurring in my cases is whether or not that requirement was met. Because, for example, the arbitration clause didn't have a time limit. It just said that they must mediate before, but it didn't say, you know, within 10 days of notice of an issue, they must mediate. And then one party can hold the other hostage by deciding never to do it.
Right.
Right. So you don't want that kind of situation. And then that adds cost to your dispute because then you both have to sit there and litigate whether you can litigate. And that's just a huge waste of resources, right? Why would you do that? So you've got to put in the money in the front end to have somebody really do it smoothly, correctly, and the right way so you don't have problems and costs down the line. It's like insurance. You don't get insurance after you've broken your arm and you're in the hospital. You get insurance in advance. It's something that you pay for before so that when a situation comes up, you're in the best possible position. That's exactly what you're doing with a contract.
Of course, there's a conflict in people's mentalities between being preventative and then incurring costs that they don't see being necessary, because prevention means I'm willing to accept these upfront costs to avoid a lot more expensive situations or scenarios after, right?
Yeah, and some companies just don't have the budget and they have to make tough decisions, right? And I understand that, but I don't think sometimes they fully appreciate the cost down the line. I cannot tell you how many clients I've had that have come to me with a litigation issue and now they have us handle all of their contracts because now they understand the value.
Of course, and sometimes it honestly means it's so crippling, the costs are so crippling that that business can no longer function.
Okay.
I see that with the visas that I do. You have to make sure that when you're calculating costs for running your business, that you have those contingencies there as well. So if somebody is genuinely interested and has the foresight before they sign a deal to put in that arbitration clause and to protect themselves, or they have potential arbitrations that they would like to pursue as opposed to litigation, how do they get in touch with you, Tiffany?
That's very simple. They can reach me by email at tiffany.compress@fisherbroyles.com.
Thank you so much for joining us today and for all your knowledge. Appreciate it.
Thanks for having me. It's been fun.